Welcome back, everyone, to the Radical Moderate Podcast. I am your host, Pat O'Brien. And for those of you who listened last week to part one of this interview with civil rights attorney Dave O'Brien, we went into, in deep depth, the situation in Minneapolis with the deaths of Renee Good and Alex Preddy and just use of force. And for those of you who didn't hear that episode, Dave O'Brien is based out of Iowa, which is also in the 8th Circuit, same circuit that Minnesota is in. And all he does is use of force cases and things surrounding that. And so, Dave, this week, I want to talk about some topics we didn't get into on the last episode. I want to start with qualified immunity. You mentioned that several times for the non-lawyers and the people who, even lawyers who just never done a case like this. What does that mean? What is the policy and legal meaning of the term qualified immunity?
Well, of course, immunity comes from sovereign immunity, which is the king can do no wrong. And one of the reasons why we had a revolution here in the colonies 250 years ago was because we didn't want to be ruled by somebody that can do no wrong. But that's where it comes from, sovereign immunity, and then the king's agents in that context can have some qualified immunities as they developed. And in this context, it does make some sense for the reasons we talked about a little bit in the last episode, and that is that we're asking law enforcement officers to engage in conduct that if we did it might be a criminal sanction on its own, like assaulting someone, grabbing them, pulling them, restraining them. And if they need to do that in order to protect themselves or others, that's what we want them to do. That's what we hire them. And so it would really not be a very workable system if they could be sued every time they touch somebody. And that is because they have, under federal law, qualified immunity to engage in that conduct as long as they do so in an objectively reasonable manner. And then under Iowa law, I can always file a claim that an officer assaulted somebody, but I have to establish that they did so without justification. And as long as they're justified in doing what they did, then they're exonerated. So it's an important factor. There's a lot of criticism about qualified immunity because it's kind of been turned into something that makes it almost impossible to win in some cases, particularly new sets of facts. The U.S. Supreme Court added the term clearly established constitutional violation. It's not in the statute. In the Harlow case, the Supreme Court added that. And that's been, a lot of courts have run with that and said you basically have to come in to them with a case that says it was clearly established that this constitutional right was violated. And if you don't have that, oftentimes you will lose on qualified immunity. So it's highly technical. In my view, there's a solid justification for having that factor set out, but I think it's evolved into something that's almost unworkable, and it needs significant modification in order for us to hold police accountable when they do act objectively unreasonably.
Well, and let's talk about kind of the policy, and even if it's legislative, be a state legislature or the U.S. Congress, you're around this stuff all the time. You handle these cases. You're not, you yourself don't have a police officer background or anything, but you stated in the last episode that 90% of the time law enforcement's doing a very tough job exactly the way we would want them to do it. And of course, we all want to know that if we call 911, we want some help. We want that help, and we want the officer to have some discretion and that sort of thing. If you were advising, I don't know that the Minneapolis situation, or even if you go back to, I think, 2014, Michael Brown, I don't know that you're going to see any legislative reform necessarily, but let's say for a second we did, and you were advising whoever and say, look, we really want to get this thing right. The law needs to be good for both sides. What would you advise a legislative body to do to make the law more clear and fair on the citizen side and the law enforcement side?
Well, I would remove the clearly established provision and just go back to the constitutional violation. If you have the standard as an objectively reasonable officer, that would not, or that either would have acted that way or would not have acted that way, and the result the liability depends on the result. The answer to that question, I think you're good. The problem, anytime you try to get into specifics, is that these fact patterns just are all over the place, and you just never know how it's going to come about. And so it's like driving a car, right? I mean, you have to drive your car in an appropriate manner, and if you drive your car in a negligent manner, you can be held accountable. And that negligence can arrive in many different ways: speed, recklessness, doing something you're not supposed to do, or failing to do something you're supposed to do. And it just, every case is different. And so I think you need to let the courts sort it out with a reasonable, appropriate standard. I think qualified immunity should be allowed for these officers. So if they engage in conduct, they can be immune for conduct that was justified, but also held accountable for conduct that wasn't. And I don't think the fact that it's clearly established or not makes a darn bit of difference. If your constitutional rights have been violated, you ought to have a forum for getting compensation for those losses. I mean, that's what we're about, a constitutional democracy. And we have the Bill of Rights for a reason, and we ought to be able to enforce it.
I don't know if we got into the topic of imminent threat. Is that a legal principle? Is that applicable everywhere, or am I making stuff up here?
No, imminent is part of the analysis on the objectively reasonable use of force. It has to be an imminent threat. So you have to be able to conclude that this person is imminently going to put someone else in danger. So it's pretty easy if they're turning towards you with a gun. But what if you know that they're driving to their home to get a gun to go to their former mate's house and inflict them with harm? Well, can you just shoot them on that point? No, because the threat at that point is not imminent. So it does play a role, but it's usually I haven't had a case anything like that where somebody said, "Well, I got to shoot him because an hour from now he was going to go do something wrong." I haven't had that one.
It needs to be happening.
I'd be concerned. Yeah, I'd be concerned that it wouldn't be clearly established. But
yeah, it sounds like it needs to all be happening at the same time. You know, that makes perfect sense. There's two things I want to make sure we talk about. We can do it either order you want. Contagious shooting. I hadn't heard that term before, but we all know the idea that the first bullet, you're saying you got to justify every bullet that you're shooting. And then the second thing you talked about, supervisory role here, meaning you've got the officer, the cop on the beat, but then you're dealing mostly, I think, in your practice with a lot of police, maybe municipal police, maybe you're dealing with a state entity, maybe ICE. I don't know if you said you had any ICE cases, but either one you want to talk about. What is contagious shooting? And then what is the potential civil liability for the higher ups, and what do they have to do? I mean, they weren't there. They didn't pull the trigger.
Right. So just with the contagious shooting, I think this case is a perfect example of it. One of the good things about what I do is I get a chance to engage with a lot of police practices experts. Most of the time they're highly qualified former law enforcement officers at some level. In some instances, they're academic people that have PhDs and done research in this area, written books, many books on these subjects. And the contagious shooting is something that the experts have identified, that officers have a tendency that if one of the other ones shoot, they just fire away based on the other, thinking the other officer must have seen something I didn't see. And so it does become a problem because that is not considered a justifiable use of force. Well, he fired, so I fired. Just like Mom used to say, well, if they all jump off a bridge, are you going to jump off a bridge? And the answer is no. I mean, theoretically, we jumped off some bridges, I'd imagine, in our days, but you know what I'm talking about. So contagious shooting isn't justified, and that's an academic term for it. They have some other terms that they call it, but yeah, you can't just shoot because the other guy shot. Now you can rely on information from the other person. Like I was told he has a gun, and then I came around the corner from where the officer who just radioed that this guy has a gun, and he has a red shirt on, and he turned and he had his back towards me, and then as he turned around, his arm was whipping around. And it turns out it was a cell phone. But, in that case, you're probably going to be justified in firing because you could rely on information provided. But you can't just rely on that officer's decision to use deadly force. You have to make your own independent judgment, and that judgment has to be objectively reasonable.
On this question of the multiple shots, contagious shooting, I'm going to kind of take the other side of the argument a little bit and say, I've heard a lot of lectures from experts about how the brain works. And, we have a fight or flight mentality. And basically when you feel imminently threatened and of serious bodily harm, going back to the caveman days, if you're worried a lion's going to jump out of the woods, I think what I think a lot of the brain expert people would say is your brain shuts down and you're just trying to defend yourself. There's no thought of Supreme Court case or even probably what I got trained. And just for me, I think that once that first shot happens, it's going to be really hard to think that somebody's given a lot of thought to the second, third, fourth shot. But how does the law view that, though? Are you saying that, no, they are held responsible for the second shot? So let's say the first shot hits them in the leg and then they wait a second, but then the second shot hits them in the heart. What's the legal distinction between those two shots? How does it work under the law?
There has to be justification for each shot. The scenario that you gave, as long as the person is still holding the gun and moving in an aggressive manner, the second shot is entirely reasonable. If the first shot hits him in the leg and the guy drops the gun and then you shoot him in the heart, you could have some issues. Now, depending on how close it is in time, did you pull the trigger? There's a perception reaction time analysis that comes in terms of deciding to pull the trigger, which takes a bit of time, a second maybe. So it all goes into play, but you have to be justified. And if I've had that case where they drop the gun and they get shot anyway, and we were civilly able to recover in that case because the justification previously was present. They told him to drop the gun, he dropped the gun, and then later they shot him. They can't do that because he doesn't pose that imminent threat of serious physical injury or harm at the time. Listen, this isn't easy, but I do want to address one of the points you're making. You are 100% right that there is sort of a reptilian nature that comes into play for people. That's why we have officers that have to go through training, 22 weeks at the Iowa Law Enforcement Academy. And we spend millions of dollars a year in the state of Iowa training law enforcement officers to be able to act reasonably and appropriately under these very, very difficult circumstances. And that's why we do that. And they have to follow their training. And it would be the same way to say, well, the doctor cut the wrong whatever part of his body. So,
right.
Come on, he's in there. It's all bloody. I mean, let's just give him a break,
Well, I want to go to that for a second.
He's been trained to handle these situations, and officers are too. And they can, and in my view, should be held accountable if they don't use their training and follow their training when faced in circumstances. Although I will tell you, it does happen. I've got what I call Barney Fife's cases, which are cases where it's a well-meaning officer, but they get in a situation that's over their head and they react inappropriately. And I still believe they should be held accountable, maybe not punitive damages, but I still think they should be held accountable. Those cases are not as bad as the Captain America cases, where the officer comes in and, gung-ho officer, I'm just going to fire away. But there's still, it's still a violation of people's constitutional rights. Somebody's still dead because this officer screwed up, and they may have been Barney Fife trying to get the bullet out of their pocket. But that doesn't justify the use of deadly force of the fact that the officer might be bumbling. I don't buy that one.
Yeah, I want to go back to something because you made the analogy with a doctor, let's say a surgeon in this case. A surgeon has to go to school for so many years and be a resident and all that before they're allowed to open up your heart and start moving stuff around. And of course, everybody says, well, I want the best surgeon, et cetera, et cetera. Now, you could easily say, yeah, but Pat, you're consenting to that. I mean, you don't have to let anybody do surgery on you. That's your choice. But still, I think that the training, the point here is that their training is top level in the world, right? They're getting the best training before we would say they're qualified. And we absolutely are going to second guess them. If you die on the table, the surgeon could be sued. They got to pay malpractice insurance. Like, did you do your job? And I'm wondering, I mean, how much training do we have? Enough training? And we talked about ICE in Minnesota last episode. Let's just broaden it out to your standard. You and I were both born in Sioux City, Iowa, a town of 100,000. That's probably got a pretty decent police force. But then we know places like Spencer, Iowa, that have 10,000 people. You got different levels of probably professionalism in law enforcement. Is the training good enough that you, across Iowa and maybe the whole country, that you can hand somebody a badge and a gun and say, look, we trust you to do the right thing and not kill people that you shouldn't have killed? Because just like a surgeon, they literally have the power of life and death. Is the training sufficient from your experience?
Well, the answer to your question is no. It's not. It's not sufficient. I don't know how it compares worldwide, but I can tell you that in Iowa, you can be a law enforcement officer in Iowa if you have a high school degree, and then you go to the Iowa Law Enforcement Academy for 22 weeks. And then you are given a gun and you are told that you can use deadly force if justified. If you're facing an imminent threat of serious injury or death, you or another. And that's why, to me, it's really amazing that we have so few of these in my home state. I can't speak, and DHS is a whole different story, whether they've gotten the proper training, what orders they're getting. And we want to touch on that because you mentioned the Monell liability for supervisors. But in the context of the training, they do spend a lot of time working on how to identify an imminent threat of serious injury or death and how to appropriately respond. They have concepts that they definitely train on, that like distance plus cover equals time, and that's in a situation where there's a standoff. Anytime an officer can create some distance from a threat and be behind cover, that gives them the one thing they're looking for in order to try to diffuse a situation, and that's time. And the longer the situation goes on, the more likely it's going to be resolved in a reasonable manner. So they have some training. It's not enough, and then they have ongoing training every year too. A lot of it, weeks of training every year where they're going through these and should go through these. I think they should have more. I think the academic standards should be a little bit higher. But then again, there's a need out there for law enforcement officers. And you have to, public people in public policy positions making these decisions have to understand that. And so I don't know what the ratio is for officers to population and whether we have enough that are applying, and if we're getting the wrong type or the right type of people applying. I usually, when I get into these cases, I find out a lot about this person, and sometimes it becomes pretty obvious the type of person that is a law enforcement officer, and they're being overly aggressive because the best night of their life was having, 3 tackles for loss in the high school game against a crosstown rivalry. And, that may not be the person you want with a gun in their hand deciding whether you pose a serious injury or threat. On the other hand, you get some of these guys that have the training and have been around. I've talked to a lot of police officers that have never fired their gun in the line of duty in an incident. They, of course, do all their training, and those are the kind of guys you want around and present when stuff's about to go down, because calmer heads are going to prevail. If there's a way to avoid using deadly force, you're supposed to do that. It can't be the first option.
Yeah, and I think it's kind of an unfair analogy that I put there between a surgeon who might be paid $500,000 a year and an officer who might be getting paid $50,000 a year, or even in a bigger municipality, 75. And part of thing I want to make a comment on is I put a lot of stuff back on the citizens. And if you were to go to any town in America and say, look, your police force is underpaid and undertrained, and you need to pay for it. We need to raise your taxes because it's not good enough. I think their first question is going to be like, have we had big problems? Nobody's died. And it's not until something happens and somebody says, well, we have a problem. So I bet that most law enforcement would love to have more training and love to be paid more and that sort of thing. I want to get into something we danced around earlier, which is the supervisory role here. And whether you want to go back to Minneapolis and how the policy and the supervision there, if you want to talk about that, or if you've got some cases that you want to talk about. So let's just say you got an officer or an ICE agent, whoever on the beat. How does their boss get involved? Like usually creates legal liability problems for that person?
Well, there is no respondent superior liability in this context in 1983 cases. So everything we've been talking about is that officer that uses deadly force has to justify their conduct, but their supervisors aren't responsible for that conduct in most situations. The exception to that is if the supervisors on up the chain of command have put in place a policy, practice, standard of engaging in such abuses, of violating people's civil rights. And that's a Monell, it's called the Monell case. It's another U.S. Supreme Court case where they said there's not just supervisory responsibility. In a standard negligent case for driving a car or slipping on a sidewalk, a supervisor can be held liable because they're ultimately responsible for the works of their agents that work for them. But that's not true in these cases. Supervisors are only responsible if they put in place a policy, pattern, or practice that allows this kind of conduct. And those are very difficult to prove. But we all read the news. We see what these orders coming down in Minneapolis and DHS. Now they'll have to get to the bottom of all that. But I can pretty much guarantee you that those claims will be made. And if they develop discovery showing that supervisors on up the chain of command were implementing these policies that led to the violation of Ms. Good and Mr. Preddy's civil rights, they potentially could be held liable under this Monell case and that liability. And you certainly have to get to the bottom of that, but it's possible.
Yeah, there's going to be a lot more investigation. And certainly if you were the civil rights attorney suing, you're going to ask to see, is there a memo that's damning and text messages and all that. I want to ask you, to the extent you can share, because we're kind of talking about there's the officer, and I know an officer can certainly be civilly liable, but most officers are not going to have assets that they're going to be able to pay a victim's family. So you're probably getting it from the municipality, the county, et cetera. What type of, verdicts and the amount of a verdict is a signal to a community and to everyone of like this. If you get a $5,000 verdict, to me, that says nobody cared that much. Nobody thought that was that big a deal. You get $1 million verdict, that is saying this was bad. This needs to stop immediately. There needs to be reform. What in Iowa, which for those who've never visited the fine state of Iowa, as much as I have, it's about 3 million people. It's an agricultural based Midwestern state, a lot of corn and that sort of thing, a lot of good, solid Midwestern people. What have juries, when you've taken cases in Iowa to trial, what have juries said about this liability? What kind of damages have they done? And I don't know if you can talk about settlements. They might be confidential, but what kind of messages have juries said about officers who just went too far?
The answer is none of this is confidential in terms of settlements, because you can't have a confidential settlement with a government agency.
Good point.
It's one of the advantages of what I do is everything is public, and it does have an impact, I think, because people read about these cases and they know what's right or wrong, and I think it helps police officers know what they can do and what they can't do. But juries, here's the thing: these cases all follow the same pattern in terms of how they come about. I've taken a few of them to trial, and the verdicts have been quite substantial. But people have a really high level of saying, "All right, we like law enforcement officers. When we call them, they come and do a good job, and I want to be able to rely on them." So, Brian, you're really going to have to convince me that this guy screwed up. But once we convince them that this guy screwed up, they're like, "Okay, that's it. Where do we sign the check? What's a big enough number here where we can get people's attention that we don't want this happening again, and we want to give these people full compensation for the losses that they've suffered." So, for example, I had a case where the guy, I think I mentioned it in our previous episode, the local officer decides to take over a chase that everybody stopped doing, including state troopers, because it's not worth the risk. High-speed chases, somebody else could get hurt very easily. And this guy's not in my town, and he chases this motorcyclist out the other end, doesn't intentionally, in my view, doesn't turn his camera on. It intentionally runs right into the guy and kills him. And the jury looked at that and said $4.5 million, and they appealed it to his mother and his father for loss of consortium, and people took it. The city took it all the way. City of Manchester, Iowa, small town, took it all the way to the Iowa Supreme Court. We just got a decision a few months ago, and they had to pay that. And there's insurance coverage. These officers, it's not coming out of their pocket. The cities, just like they have motor vehicle collision coverage for their cars, they have police practices coverage for their law enforcement officers. Typically, that doesn't include punitive damages, although I have seen some policies now where punitive damages have even been covered by insurance policies, which in my view is bad public policy, but that's up to the city council. And the punitive damages against an individual officer are based upon the officer's wealth. So it's not like, oh, we get $1 million because the city of Des Moines has a $250 million budget. It just doesn't work that way.
Yeah, but just so the audience is clear, a bad night at work, bad day at work for this one officer resulted in a $4.5 million liability for that, you said, relatively small city.
Yes, and they had insurance coverage to cover that. So their insurance policy had to pay that amount for the wrongful conduct of their officer, who engaged in intentional, reckless behavior, running motorcycles off the road, knowing full well at 65 miles an hour out on the highway, it was going to result in serious injury or death. And he admitted that, but he did it anyway. And then he claimed the guy he was chasing actually ran into him somehow, which he never properly explained because it's impossible. So by the time the jury heard 2 weeks worth of evidence on that case, they were ready to write a big check, and they did.
Goodness. Well, we've got a couple minutes left here, and we've touched on so many topics, but I think we could go on for hours and hours. I mean, we haven't even gone back to like the Michael Brown case in 2014. We haven't talked about the Floyd case, which sparked so much turmoil, and I worry that it didn't necessarily solve much. We didn't really get into body cams, but there's a lot we could talk about. Maybe I'll have you on. Maybe when we get some resolution on the cases in Minneapolis, maybe that'd be a good time to come back and kind of break down what you think happened. But in the remaining time, what would you like to leave our audience with? Let's say they're not attorneys and they're not police officers, just people who just want a good common sense policy. They want to know that the system makes sense. What would you leave the audience with?
Well, the whole Minnesota and DHS thing, and having out-of-state law enforcement officers come in the thousands and occupy your city is just outside the realm of anything we have to comprehend. And thank God it's not happening in my home state. And I applaud the people in Minnesota for standing up and asserting their rights. I do think it's important. My clients are never perfect. Well, I shouldn't say never. I did have two female teachers that went out and protested at a George W. Bush reelection rally, saying "Bad war no more," and they got arrested because the Secret Service told the local agents to arrest them. They took them down to the Lynn County Jail and strip searched them, and that was 8 yeyears later. 2 trials, 2 appeals to the 8th Circuit. They ultimately had to pay that. I bring that case up because we touched a little bit on Monell liability, and that case is where we got into that. I actually sued Tom Ridge in that case, who was the head of Homeland Security at the time, because he oversaw the Secret Service at that point in time. He got dismissed out of the case. The reason I sued him is because we got a hold of a memo, which was widely let out at that point in time, that the president didn't like protesters and he didn't want to see them, and they made him move them out of the way. And if there were protesters, and these people were standing on a public sidewalk, which is the quintessential free speech platform, and they were told they had to move, and they didn't move fast enough, and they got arrested anyway. And but I still didn't get Monell liability, even though I had a memo directing these Secret Service agents to tell the local officers to arrest people if they got in a place where the president could see them, because he didn't want to see protesters. But we didn't overcome the ability to do that. And I might have appealed that decision, but ultimately I got a nice verdict against the people that strip searched her, and the clients were satisfied, and we walked away from it. But I think we're going to run into a lot of issues with that in Minnesota. And I think you're going to run into immunity issues now. We might be moving from qualified immunity to just executive immunity. That's sovereign immunity we talked about. Supreme Court has basically written a blank check to the president in terms of what he can get away with. How does that apply to other people down the line, the attorney general, the director of Homeland Security? Who knows? And the good news is you'll have a lot of really smart lawyers on both sides looking into this, gathering all the facts. And I believe our justice system will arrive at the right outcome. And I'll be happy to come back and talk to you about it when that happens.
Let's put a pin in that. I think that the way that this plays out is going to be fascinating. I want to thank you for coming on today, and hopefully, as always, my audience has learned something, and I want to thank everyone for listening to the POV of POB.